interesting about the decision of 1789 and the Tenure of Office Act in the 1868. Yes.
Can you check your YouTube? There's no sound.
I know. I'm. There's something weird. It's actually not the camera, not my mic. It's it's something with YouTube itself. So I'm just going to record and upload it later.
Okay.
Yeah, I know. I noticed it. I get my own alerts. I'm recording it locally. I'll upload it later. Yeah, I don't know what it is. The mic works fine on Zoom, but for whatever reason on YouTube, it glitches and it turns off, and I can't reconnect the microphone. It doesn't let me change the. Usually on Zoom you can change your mic while you're using it. YouTube you can't. YouTube you're locked in, and if the mic disconnects.
It's the mic you always use?
Yeah. So for example, the mic on Zoom is working fine. The Zoom recording works just fine. It's just YouTube's a problem. So anyway, so you'll be up online later. Sorry, people couldn't come to class today. Who's not in class? Why aren't you here? Sheldon, man, where are you? All right, this is later.
Can't hear you.
I know. You can't hear me. Okay, well, you should be here. All right, I think I missed one class in law school. I was at a clerk's interview, so I always came to class. I had perfect attendance in K through 12. I went to school sick a lot. My mom sent me to school no matter what. I didn't miss a day. I swear, this is bad, but sorry, Mom. I had pink eye. I went to school. When you're in fourth grade, you don't even know the difference. Yeah, there's some drops and just go for it.
Did other people get pink eye?
Maybe. I couldn't tell you. Sorry, Mom. Yeah, I know. Now it's like, oh my God, in pre-K, if the 100.1 fever, they send them home. It's like immediate. It's like, oh, come on, 102, you'll be fine. All right. Push through it. You'll be okay.
An onion on your butt. Apparently that helps.
What?
An onion.
What onion? I don't know what you're talking about.
In your socks when you sleep.
Yeah.
That lower your temperature?
Apparently.
It's supposed to remove toxins from your body.
And vapors,
I once gave my daughter Tylenol for school. It's like, you gave her Tylenol, you're cheating the fever, and they sent her home because she said, oh, I gave her Tylenol. They're like, that's like cheating the system. Apparently, it brings the fever down. That's the point of Tylenol. You'll see when you're parents, because when your kid doesn't go to school, what are you going to do? There's no daycare. I mean, what are you going to do? Right? You got to go somewhere. So I haven't brought my daughter to school yet. It will happen eventually. I'm not sure. It will happen sooner. Okay. Back to speaking of removal. They removed me from being a parent, maybe. So the interesting thing about the decision of 1789 and the tenure of office debate in 1868 is that there was no judicial component. Right? These were fights between Congress and the executive branch. These were not fights between the courts and the other branches. So the court never actually said, President Johnson was correct. Right? That wasn't something that happened. But about 40 years later, actually about 50 years later, we get to the United States against Myers. Okay, so I'm just warning you. This class will be out of order completely. I am not going to focus on the cases as they're presented. I'm going to go chronologically. And you need to know Myers and Humphrey's Executor, even though those were not assigned cases. People hate me for this one, but it's true. You understand what I'm saying? Okay? You need to know the chronology. I'll just tell you. It's Myers, number one. Number two is Humphrey's Executor. Right? Number three is going to be Morrison. And the number four is Seila Law. There's some other cases in between. Those are the big ones, right? You have Myers, Humphrey's Executor, Morrison, Seila Law. And, sorry, there'll be a case decided in the next few months. That'll be the fifth case, that quintet. I don't know what it's going to be. But there's an effort right now at the Supreme Court to overrule Humphrey's Executor. It's like now. It's there as we speak. So let's get to the current old stuff first. Then we'll get to the present. I asked the court to rule Morrison v. Olson. I'll get to that later. It's fun. All right. I was arguing in the special counsel case this past summer, and I was with Judge Cannon in Florida, and I actually said, Your Honor, and I was an amicus for the court, I said, Your Honor, I'd like to preserve the issue to overrule Morrison v. Olson.
But that's good to say.
Well, I couldn't really say because I was in front of the court, and then the DOJ, the Jack Smith's lawyer was like his face was like, and then he said, did I hear Mr. Blackman correctly? He wants to overrule Morrison. I'm like, yeah. So.
Do you have the recording of the oral?
It is only a transcript, unfortunately. So, put my cards on the table. Don't like Morrison, but we'll walk through it. All right. Nick, what was Myers about? Do you know?
No.
Does anyone know? Yeah, Taylor. Right. Okay. Taylor's correct. It's in your reading. You just have to kind of just like read between cases. It's not a principal case. I could include Myers and Humphrey Executor, but it's easier this way. Okay. Here are the facts of Myers. You had a postmaster general, right? You had a postmaster. I think he was from Oregon. I can't remember where he's from. Somewhere out west, one of those West Coast states. And you may not know this, but back before the internet, being a postmaster was a very important job. It was very lucrative. When you were the postmaster, you got to hire all your friends, do all these contracts for delivery. This was a very valuable job, right? This was like the height of what's called patronage, right? You know what patronage is? When a guy comes to office, he hires his friends. Happens all the time. This was like the patronage job. Okay. So United States against Myers, you had a postmaster. And then a new president came to office and said, thank you for your service. You are fired. I want to put my own person in this office. And the postmaster said, yeah, no. Not gonna quit. Not gonna quit. Why? Because the law at the time said that a postmaster could only be removed for basically malfeasance, right? Doing a bad job. This law was designed to prevent this sort of the spoil system, wherever, to the victor go the spoils, that whoever wins the office gets to put his own people in. It was designed to basically keep a permanent bureaucracy, that people could basically stay in place for their terms. So again, the president said, thank you for your service, please leave. And the postmaster said, I'm not going anywhere because you haven't shown I did anything wrong. And again, the president didn't make any allegations about whether misbehaving occurred. He said, yup, I'm just, time to move on, want to put someone else in the office. And this goes to the Supreme Court. Who writes the majority opinion in Myers? Anyone know? Chief Justice, yeah. Taft, thank you very much, very good. Chief Justice William Howard Taft. Taft was unique in that he also served as president. He's the only person who served as both president and Chief Justice. In fact, he didn't really want to be president. He wanted to be a judge. That was like his dream. He wanted to be in the Supreme Court. So he got appointed to the Supreme Court after he was president. He was, as Justice Kagan would say, the presidentialist. He approached the judiciary for the view of, I was president, I know how this stuff works. And you know what Taft said? The president has the absolute power of removal. That Congress cannot restrict his removal power. It's an absolute removal power. Stunning, right? In its breadth. He thought that Congress cannot restrict the president's removal by making him show cause, to show that the guy misbehaved. That the president wants to remove him for any reason, no reason at all, he can do that. And what authority does Chief Justice Taft rely upon? He relies upon the decision of 1789, which he reads as showing that the framers did not favor restricting the removal power. Again, he reads the decision of 1789 as showing that the framers didn't favor restricting the removal power. I am no longer sure that Taft was correct about the decision of 1789. I think it's a closer call. I think on balance he's right, but I think he describes it perhaps a bit too broadly. What other authority did Chief Justice Taft look to? He looked to 1868. He looked to Andrew Johnson. And he said, aha, President Johnson decided that this Tenure of Office Act was unconstitutional, and he was right. Taft said that Johnson was right and that the Reconstruction Congress was wrong. Right? In other words, Taft vindicated, at least on his decision, vindicated President Johnson. right? Myers was like the most resounding victory for any presidential administration. This is like OMG. This is like the best decision ever. By the way, look at Taft. This guy was huge. No, dude was huge. He was like 300 pounds. He had previously been a judge at the Sixth Circuit in Cincinnati where I clerked, and his chair is still there. It's like this big. It's like this huge chair, so it wouldn't break. There's a story where he went on a horse and he broke the horse's ankles. So someone sent him a camel and said, "Here, ride this." Poor horse, yeah. Is that the horse?
Wasn't he the president that got stuck in the bathtub? Or
I think that's right. I think just Google it. I think that's right.
Okay.
Yeah. I mean, the guy was just huge, but he believed it, right? He believed in a broad presidential power. Bathtub, yeah. Yeah, stuck in the bathtub. Yeah, but I'm pretty sure the horse story, that might be a rumor, but I know that people sent him a camel or something afterwards to say, "Here, ride this." You're very sad about this?
Yes. How long did he live?
Why did he get on?
He lived to be 73. He wasn't that old. What's that?
Why did he get on a horse?
I don't know. He was going somewhere.
What happened?
I don't know. Why did he eat so much? I don't know. I mean, people don't always make good choices. That was terrible. That was bad. I'm sorry. That was mean. But anyway, he believed in robust executive power. Leave it there. All right. Why did he get in the bathtub? I don't know.
Joe Biden for president?
I don't know. I'm closing this tab. This is just a mistake. I should. I don't know. Google. I don't Google. Sorry. All right. So anyway, Myers was a very robust statement of executive power. And it basically recognized that Congress has no role in restricting the removal power. Everyone with me? Okay. So again, Myers versus United States was from 1920. Was it 22? 26. Myers United States was 1926. So if you were a government lawyer in 1926, you think, okay, cool. I can fire anyone that I want, right? The president can fire anyone he wants. But then Congress creates an agency called the Federal Trade Commission. The Federal Trade Commission, the FTC. And what's unique about this government agency is that they created a board. It's governed by 5 members. 3 of the members will be appointed by the president and of his party. And 2 of the members will be of the opposite party. So let's say there's a Republican president. The president can appoint 3 members that are Republicans, and the president then appoints 2 Democrats. And the Senate approves them. And these members serve a fixed year term. Maybe it's called 5 years. But what's unique about them is they can't be removed at will. Everyone know when I say at will? At will means removed for any reason, no reason at all. The president can just say, "Thank you for your service, please leave." You're fired, right? Instead, they can only be removed for what's called malfeasance, right? Neglect, inefficiency, right? The president must give some reason why, some cause why they were firing him. The president couldn't simply say, "You know what? Thank you very much for your service. Please leave." He has to give a reason. And what does that mean when you have a reason? Let's say the reason was false. Can the court come and say, "You know what? That's not a real reason. The reason you gave is inadequate. Go back to office." When you provide what's called insulation, think of like in your house, you have insulation from the cold, right? Protection. When you provide insulation, you give the person a remedy in court that the removal is not proper. They can go to court and seek maybe reinstatement, or maybe seek back pay. Okay. Yes, sir.
Doesn't the Fed work like that too?
Yeah, that comes up in Seila Law quite a bit. The Federal Reserve, the members are not removable at will. And that's actually a big issue about whether a president might decide to fire the members of the Fed. Yes, Taylor?
Is it because they were created by Congress?
Well, all these agencies were created by Congress.
That they can't be removed at will. That was just part of the terms.
I'm sorry, say again? I couldn't hear you.
That they can't be removed at will. That was just part of the terms of creating them.
Right. When Congress created the FTC, it created these offices, and the offices say these people cannot be removed at will. They can only be removed for cause. Right. But this was a big deal. Because let's say that President Roosevelt came into office and there was a holdover member, a Republican member of the FTC. And imagine this happened. President Roosevelt wrote a letter to William Humphrey and said, "Thank you for your service. Your services are no longer needed. Thank you. Peace." All right? I'm out. And William Humphrey said, "I don't think so. You have not identified any cause for firing me. Therefore, your order was not valid." And actually, Humphrey went to court. Now, interesting, Humphrey did not seek reinstatement. That's actually a big issue now. Instead, he sought back pay, right? He wanted the pay they would have otherwise gotten. Humphrey died while this litigation was ongoing, and his family stepped in to get the back pay. That's called Humphrey's executor, right? The executor of Humphrey's estate was litigating for the back pay. So this is a true story. Some years ago, I was talking about this case in class, and of course, more was on YouTube, and I made a joke. I said, "I bet Roosevelt had him assassinated to get rid of the case." I wasn't serious, mostly joking. But I said, "Oh, I bet Roosevelt had him offed." Random guy on the internet was watching my lecture. He got a copy of Humphrey's death certificate. Arterial sclerosis and hemorrhaging. That's what he died from, purportedly. That's what they said in the certificate. I don't know. But Humphrey died while the case was being litigated, and this went to the Supreme Court. So again, if you are Franklin Roosevelt's lawyer, I'll go back to you, Nick. If you're Franklin Roosevelt's lawyer, and you have the precedent of Myers against the United States, do you think you have the power to remove Humphrey?
Like the power of the United States, the president?
If you are President Roosevelt and you've read Myers, do you think you have the power to remove Humphrey? Why?
Take care of.
Right. Did Humphrey have any limitation on the removal power? I'm sorry. Did Myers have any removal on the removal power?
Limitation?
Yes.
I don't think so.
No. Okay, and this is significant, right? Myers said this power removal is absolute. So then, Ted, how did Roosevelt lose? If he has this great precedent from the guy on the camel, right? How could he lose the case? He got everything he wanted.
I think because the functions of the members of the board of the FTC were not just they were not granted by the executive branch alone. They were granted by Congress as well.
Ah, Stephen?
Isn't it like they were, I forgot the word, but it's like quasi, where it was like half and half instead of fully executive?
What does quasi mean, Stephen?
Honestly, I know what it means. I don't know how to explain it.
Anyone? Quasi. Laura?
Isn't it that power that's not exercised by the Congress or judiciary, but it's like, what did they say? Something about not being either?
Kind of, Michael?
Doesn't quasi just mean like somewhat?
That's what quasi means. Quasi means somewhat or partially. All right, I think you're all giving me very good answers. Let me try to bring it together. The court rules against Roosevelt and upholds the protections for the members of the FTC. How they get there is a bit weird. They don't overrule Myers. Myers they leave in place. Instead, they distinguish Myers. They say that the postmaster in Myers exercise only executive powers. That the postmaster in Myers exercise only executive powers. And because the executive branch has control over the executive power, the president must have an absolute removal authority. But at the time, the FTC had sort of different powers. They didn't really have core executive power. Instead, they had some sort of legislative powers. They can make rules. And they also had some judicial powers. They could adjudicate. They could decide disputes. So it was said that they had quasi-executive, scratch that. It was said that quasi-legislative and quasi-judicial powers. They had quasi-legislative powers and quasi-judicial powers. In other words, it didn't fit squarely within the executive branch. Congress gave these agencies some legislative power and some judicial power. And therefore, the president can't have absolute removal power because they're not exercising executive power. Everyone see that? Now, what's the problem there? Lauren, I'll come to you. Can Congress give its legislative powers to this agency? Can they give its judicial powers to this agency?
No.
Why do you say no?
Because the court said no. Because.
Well, the court actually, yes. The court said this was valid.
I thought they said that the premise wasn't.
Did the court say the FTC was unconstitutional?
No.
So my question again is, how can Congress surrender its legislative power, and how can Congress give judicial power to these agencies?
By using like the quasi.
Yeah.
I guess by using like the quasi power to like support.
Can Congress delegate its powers away?
After Korematsu.
This is before Korematsu.
Beforehand, technically not. I think.
What about Schechter Poultry?
Yeah, that's what they said you could. Right.
Didn't Schechter Poultry, 1936, about a year later, say that you could not delegate the power to make laws to the executive branch? So how does the FTC operate? Nick?
So when you say that the FTC can, like the Congress made the FTC and then they can't be removed, who is Congress saying that that cannot remove them?
The president can't remove the members of the FTC. It's a 5-member board.
Just the presidency, not Congress?
Well, Congress can never remove those people, no.
So they made it and they...
Congress created this agency. They gave this agency some legislative powers and some judicial powers. And they said the president can only remove the members if they misbehave. Taylor?
Is it similar to the president's removal powers and that the FTC works for Congress?
I'm sorry?
Does the FTC work for Congress so they can?
Wait a minute. Who in which branch does the FTC fall? Is it an executive agency? Is it a legislative agency?
I think he said legislative and judicial.
Yeah, but which 3 branch of government? Where does the agency fall? 1, 2, or 3? Is it? Michael?
Can they, is it because of like the Commerce Clause and necessary and proper?
Oh, that's what created the agency. But which branch of government? You were so excited. Yeah, go.
Judicial one.
Is it judicial branch of life tenure?
I mean, for bad behavior, but it does say that Congress has the enumerated power to create inferior courts of law.
Yeah, but you're right, but are these life tenured members?
No.
No. So which branch of government does this fall into? Stephen?
Is that offering?
Or is it none of the above? So administrative agencies don't fall anywhere in the 3 branches. They sort of fall all the above, or maybe none of the above, right? Justice Jackson described these as sort of this headless 4th branch of government, right? They exist outside the 3 branches. And that's what Congress was trying to do. They were trying to create these entities that were outside of government, that were sort of these independent agencies, that were not subject to politics, that would be insulated, protected from the president. The idea was that these independent agencies would provide better advice, better rules that are not governed by whatever the politics of the day are. You have these bipartisan boards, right? They're not subject to politics. And these bipartisan boards would help us have better policy without concern of whoever's in office today and however they're trying to appeal to voters. This was a big deal. This was the change in the 1920s and 30s of creating these agencies. So the Federal Trade Commission, the Federal Communications Commissions, the Security Exchange Commission, right? All these alphabet soup agencies you've probably never heard of, right? All these ABC entities that have independence from the president. Humphrey executive was about the removal power, to be sure, but it was also about the constitutionality of these agencies. Can Congress create these agencies that are outside the executive branch, that are outside the judiciary, that are outside the legislative branch, that sort of just hover between the branches? And Humphrey executive said, yes, they can create these entities. Yes, Stephen?
I think we're going to get to it, but how is Humphrey still good law if they were criticizing him really heavily in the two cases we read?
Oh, I'll get to that. I promise. Yeah, let's do Humphreys and I'll get to the other cases. Okay. Now we have to also know is that this is before 1937. Remember I said in 1937 that's when the court threw in the towel, right? Schechter Poultry was 36. This was 35. This was the last time the court said to Roosevelt, no, you cannot do this, right? Congress creates these independent agencies. Roosevelt, you can't just fire these people at will. Roosevelt, you can't regulate local wages because this is for Congress and not for you to do. At least as far as 35 and 36, the court was still sort of enforcing the separation of powers. Now, Humphreys was unanimous, right? Was it unanimous? I think it was. Burn that one, actually. But Humphreys was basically repudiation. Yeah, it was unanimous. Humphreys was repudiation of Roosevelt, saying you cannot fire these independent commissioners. We will rule for Humphreys. But the way they did this is sort of bizarre. They make up this test where they say, well, if the position is actually quasi-legislative and quasi-judicial, it's not really executive, therefore the president doesn't have this power, and Congress can impose a protection. This was never a well-reasoned decision. It was very much a decision that was narrow to the time in which it was decided. They were deciding the case for the day, and that's what they did. So again, Humphrey's executive was 35. Myers was 26, so an 8 or 9 years difference, right? So in Myers it said, fire away! And in Humphrey said, you can't fire these independent positions. So it created this test for several decades in which if you were an executive official, you could be removed at will. And if you have this quasi-executive, quasi-judicial position, you can be removed for cause. That's how the law existed until at least the 1980s, maybe later. Okay, everyone get Myers. And Humphrey. Yes, Fidel. Louder, please. Independent can only be removed for cause. And everyone else. So if you're the Secretary of Defense, right, the Attorney General, you'd be fired at will. If you only exercise executive powers, you're removed at will. Right, but again, we'll get to Seila Law in about 20, 30 minutes. Things get a little bit different there. Are you wearing a Nixon shirt today? Did I see that right? Do you wear that today for Watergate in particular?
No, I just grabbed it.
Do you have a lot of Nixon shirts?
No.
I don't. Anyone own a Nixon shirt?
No.
It's okay. No, stop. I'm sorry. I've already got in trouble today. I'm sorry. Yeah, I was at a law school last week. I was at Michigan, and a guy had a Nixon button on his backpack, a Nixon campaign button. It's like, whoa, that's vintage, I guess. Okay. Yeah, people have stuff. All right. That brings us to Morrison against Olson. Sad. Ted Olson died about 2 or 3 months ago. He was a really great guy. He was George W. Bush's Solicitor General. He worked in the Reagan administration. He argued Bush v. Gore, among other cases. Really cool. He would always hold a reception at his house every summer for Federal Society students. And if you were the chapter president, you go to this reception at his house. It was so cool. he had this palace. I've never seen a house this big, this ginormous backyard. And you have all these like young lawyers there, a lot of people there, and like you invite Supreme Court justices there. Yeah, it was so cool. So like I have a picture in my office, so she goes like Alito's walking around in a Hawaiian shirt, and Robert Bork sitting there on the patio, and like Kavanaugh. All these people were just hanging. He wasn't justice back then, but they were all there. It was a very special day, so I missed Ted Olson. He was a really remarkable guy. Morrison. So let's talk about Watergate. Okay, I don't think any of you were alive for Watergate. No, I was not alive. I don't think so, at least. President Nixon ran for election and prevailed. Okay. During the run-up to the election, there was a break-in at the Watergate Hotel in Washington, D.C. If you've ever been to the Kennedy Center, which is under new ownership apparently, pay attention. Right. The Kennedy Center is basically across the street from Watergate. So if you've ever been to the Kennedy Center, you've probably seen the Watergate Hotel. The reason for the break-in is actually still not entirely clear. We don't really know why it happened. But what we do know is that after the break-in, President Nixon became aware of it. Because a number of people who broke in were, let's say, affiliated with his campaign. They were related. The exact relationship is not entirely clear. But what is clear is that Nixon tried to engage in the cover-up. He tried to make the problem go away. And by the way, presidents routinely make problems go away, but Nixon had a problem for himself. He had tape recorders. Everything was recorded in the White House. Other presidents had recorders, but his became public. So what happened was there was allegation that Nixon was involved in a scandal. So the where is it? The Attorney General, his name was Elliot Richardson, appointed Archibald Cox as a special prosecutor to investigate what happened at Watergate. And as the investigation developed, Cox issued a subpoena to Nixon. That is, Nixon, please turn over the tapes. This created a weird separation of powers issue because the special prosecutor worked in the executive branch. And usually the executive branch doesn't subpoena itself. Right? The president's the head, he gets to decide what happens. But Elliot Richardson basically made Cox semi-autonomous, semi-independent. Nixon said, no, I am not going to honor the subpoena. And this led to what was often called the Saturday Night Massacre. Right? So Nixon said, you have to fire Cox. What's interesting, Nixon could not fire Cox himself because Nixon didn't appoint Cox. So Nixon said, fire Cox. Richardson said, no, I will not do it. Now, why? This is part people just don't know. When Richardson was being confirmed, he promised the Senate that he would support the special prosecutor. There was nothing wrong with Nixon's order to fire Cox, but Richardson promised that he would keep the special prosecutor in office, and I will not do it. So when you're in government and you get an order you want to do, you resign. Right? You can't disobey the president, you resign. So he resigned. Then the number 2 guy comes up. His name was William Ruckelshaus. Funny name. He was the acting attorney general. Nixon said, fire Cox. And he's like, no, I resign. Sensing a pattern here, right? This created one more rub. Robert Bork, the guy sitting at Ted Olson's patio. Nixon said, fire Cox. And Bork said, you're fired. And that was it. Cox was out. This was called the Saturday Night Massacre. But this massacre did little to address Watergate. You're just firing prosecutors. You're kicking the can down the road. So what happened next is that Bork appointed a new special prosecutor. His name was Leon Jaworski. And what did Jaworski do? What do you think he did? He put a subpoena to Nixon. So all this massacre stuff just kind of kicked the can down the road. A new special prosecutor was appointed, who then subpoenaed President Nixon. Nixon refused to comply with the subpoena. And this led to a case called United States against Nixon, which I now think was wrongly decided, very wrongly decided. But the court held that Jaworski's subpoena was valid. Now, in what context did Jaworski issue the subpoena? This matters to the Vance case next week. The Watergate defendants were on trial. And under the Constitution, if you are a defendant, you have the right to evidence in your benefit. Right? The defendants wanted the Nixon tapes. They thought it would help them in their trial. So, in fact, Jaworski was asking it not to go after Nixon, directly at least, but to help the defendants. The defendants had this right to get this information. So the court said, to ensure that people have the right to their defense, and they've evidenced their defense, you must produce the tapes. Okay? After this happened, this court ruled against Nixon. Everyone sees this story, right? He resigned the presidency. He went out the Air Force Marine One, and he stepped down as president. But this led to a lot of laws being enacted. One of the laws that was enacted was the Ethics in Government Act, the EIGA, the Ethics in Government Act. This law did a lot of stuff. Okay? This law created a process by which independent counsels could be appointed. Right? This law created a process by which independent counsels could be appointed. Critically, these independent counsels were not appointed by the president, and these counsels cannot be removed by the president. This was a reaction to Watergate. They're saying, we don't want to get in a situation with another Saturday Night Massacre where the president orders the firing of all these prosecutors. We don't want this. We want these prosecutors to be independent. The actual independent counsel statute was passed in the late 1970s, but the Supreme Court didn't consider its validity until Morrison and Olson in 1988. Okay? So, a funny story. At the time, right? At the time that President Reagan was in office, who was the secretary, who was the EPA administrator? Her name was Anne Gorsuch Burford. So again, when Morrison was being decided, Neil Gorsuch, the justice, his mom was the EPA administrator. And his mom basically got involved in a bit of a scandal. Details are not very important. And Ted Olson got caught up in that scandal also. And it was asserted that Ted Olson lied under oath. And eventually, Gorsuch's mom resigned. And then the mom puts in her biography that her son told her, you should never have resigned. You didn't do anything wrong. You did what the president ordered you. Why are you quitting? Gorsuch said, you raised me to be a quitter. You raised me to not be a quitter. Why are you quitting, Mom?
You raised me to be a quitter.
The opposite. Maybe somebody gets that advice. I don't know. So, well, the ironies is, the world is flat. Gorsuch was involved with this 50 years ago, and he's probably going to vote over Morrison. Olson was accused of lied. Who wants to walk me through? Who's next? I lost where I am. Anna, you next? Anna, what's the process by which an independent counsel is appointed under this law?
I believe they're appointed by the Attorney General. Is that right? Or
Yeah, give me more. You're not wrong, but just you have to. It's a process. I want to know about the process.
Okay, so. So it says that an independent counsel appointed under this charter may be removed from.
You're giving me the back end. How they appointed?
I'm not entirely
Anyone? Yeah, Ted.
The Attorney General has to find reasonable grounds for there to be an investigation, and then a special division, they call it, of 3 judges works together to determine jurisdiction, and through that, if they determine that they do have jurisdiction, then they appoint a lead independent counsel.
Okay, that's good. So usually, how does a prosecution go forward? The Attorney General or United States Attorney, some prosecutor says, I think that there's enough here to investigate a crime. I think there was some crime that was committed here. But this law is a little different. It says, if the agent determines that there's some reasonable grounds to believe investigation is warranted, which is a very low standard, he has to then make an application. Right? He goes to a court. Right? It's what's called the special division. This was 3 judges on the D.C. Circuit Court of Appeals appointed by the Chief Justice. And the special division would then appoint an independent counsel, and it would define the jurisdiction, that is, what this person could investigate. But that wasn't fixed. The independent counsel could always come back and ask for more authority or more jurisdiction. Okay. So again, I think it was a report from Congress said that maybe Olson lied. I don't think he did, but that's what the report said. And they asked for the appointment of the special counsel. And they actually appointed someone else, and he stepped down. Then they appointed Alexa Morrison as a replacement. Okay, so again, the president's not making this appointment. It's being made by the courts. And the president can't make the removal. And indeed, the Attorney General can't make the removal unless there's certain cause. And by the way, if they want to remove the special counsel or the independent counsel, they have to go to court to decide if the removal is appropriate. So basically, once this person's in office, it's almost impossible to remove them. And their budget is basically unlimited. They can do whatever they want and investigate whoever they want. And even if the investigation starts out over here, you go all the way over there and find different things that are related. During the 1990s, I mentioned Monica Lewinsky in the last class, I'll do it again, an investigation to Bill Clinton began over real estate dealings in Arkansas, and that expanded all the way into sex in the White House. These things have a way of just growing in ways that are not even anticipated. So let's look at the text of the Constitution, right? Again, the president shall nominate, and by with the advice and consent of the Senate, appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court, and other officers of the United States. Okay. But Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of the department. Damon, where does Alexa Morrison, where does the independent counsel fit in the appointments clause? Where does she fit?
So it's inferior to the Attorney General, so it's not. So they said that's why it would be considered an inferior.
Well, hold on. Does the Attorney General make the appointment?
No.
Who's making the appointment?
10 judges.
So where does Alexa Morrison fit in the text of the appointments clause?
Technically doesn't.
Well, no. I mean, according to the majority, it does.
Well, it's technically the Attorney General has somewhat the power to go through with the appointment.
You just had the courts appointed, right? Read the text. Where does the majority place the independent counsel on this text?
Appoint other officers. Yeah.
What? Yeah.
Judges of the Supreme Court and all of.
But that's the president makes the appointment.
Right.
Who's appointing the independent counsel?
Oh, okay. So Congress may, by law, vest the appointment of such inferior.
Ah. In who? Who gets to appoint them?
Congress.
No. Rick?
The president alone?
Is the president making this appointment?
No.
Who's making this appointment?
The 3-judge panel?
Where does that fit in the text? You're killing it. Read it. President alone in the...
In the courts of law.
So what's a court of law? Is a 3-judge panel a court?
Yes.
Yes. Oh, you're killing me, guys. Yes. Courts, yes. So according to the majority, right, if the independent counsel is validly appointed, the only way it can happen is if it falls under this provision. The 3-judge panel is a court of law. So then we have this argument. Congress can vest the appointment of such inferior officers in the courts of law. So there's a distinction between inferior officers and what are called principal officers. Inferior officers and principal officers. Principal officers have to be appointed by the president. However, inferior officers can be appointed by the courts of law. So I'll give you an easy example. A federal judge, right, a federal district court judge, a Supreme Court judge, circuit judge, are they principal or inferior? It's actually not so easy. But assume they're principal for a moment, right? Actually, not so sure. I think they are, but not a debate for today. If they are principal, they have to be appointed by the president. They cannot go through another appointment process. The president appoints them, and they're confirmed by the Senate. For example, a magistrate judge, right? I got in trouble for saying this, but it's true. A magistrate judge is not appointed by the president. A magistrate judge is appointed by the court of law. They're not confirmed by the Senate. The court of law appoints them. They are inferior officers. That's not to say that they're lesser people. They're not good. It's that they're not principal. They are inferior. So the Constitution anticipates that the courts will also appoint court employees. Right? If you're working for the executive branch, you're not a higher-ranking official. You're a low-ranking officer. You're inferior. You can be appointed by who? The president or the head of your department. Right? The head of the agency, the secretary of whatever can appoint you. So the Constitution anticipates there's some high-level principal people. They're by the president alone, confirmed by the Senate. And there's some lower-level people, inferior, who are going to be appointed by either by the president or by the courts or by the head of the department. Congress can choose which one makes the appointment. What's sort of weird here, though, is that the court is not appointing a judicial employee. The court is appointing a prosecutor. Can courts appoint a prosecutor?